Did you get some now? Say goodnight to them. You heard? But I read on your No, Daddy alone.
Can you put her back behind the gate, please?
Come. Stop it.
Hello, good afternoon. Well, good
Good
evening.
afternoon. Good afternoon. Oh yeah, same difference. How you feeling?
Good, just staying warm. What about you?
Same here. Same here. Been a very unsettling time. With the weather. I'm a Florida boy, so I'm not used to environments like this.
I know. I seen a video on Instagram that was like Florida basically forgot their identity because this is supposed to be the sunshine state.
Right, 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 right. Exactly, exactly. But wow, I'm super excited to get this started. Thank you for coming on here on a Monday night. I know you all have busy schedules, so I really appreciate
Thank
it.
you. Thank you so much for having me.
Of
I
course.
did get unexpectedly a meeting added to my calendar after this one. So I wanted to know, is this supposed to end at 9 or 8 o'clock?
We're gonna keep it pretty brief.
Okay.
For the most part, we're gonna try to run through everything. It's gonna be deed to legacy. We're gonna talk about Lady Bird deed versus trust. Does it
Hmm.
make sense for the audience? So essentially, it'll be split up between those who have a lot of assets, and the
Hmm.
trust makes sense for them, or it'll be someone who has one property.
Hmm.
The Lady Bird deed would be the best for you. So we're gonna try to run through that and then do Q&A afterwards.
Okay, perfect. And I did get a PowerPoint prepared that's focusing
Awesome.
on the revocable trust first and then the Ladybird second. And so
Okay,
whenever you want, I'll just share my screen and then we could go from there.
we'll get right to it. Perfect, perfect. All right. Um,
And good afternoon, Jeffrey. I see he's there. I don't know if he's busy with another call.
yeah, I'm not sure as well, but we're gonna start promptly at 7. Thank you everyone for meeting. Come on out today, 6 to 9. Okay. Okay. All right. Let me just check in with Jeff. Thank you everyone for joining. Greg, Val. We're gonna allow, I'll say like 5 minutes for everyone else to come in. We're still admitting people as they come in. And just to confirm, can everyone see my screen?
Yes.
Yes? Okay, perfect,
Yes.
perfect. All right. So again, we're gonna give about like let's say 3 more minutes. Let everyone come in. And yes, thank you so much for joining us, guys, on a Monday. I know that everyone has very busy schedules, everyone has families. So I want to say thank you guys so much. To clap it up for everyone that's here on a Monday. And yeah, it's gonna be a jam-packed session. We're gonna learn so much from our attorney. If you want to introduce yourself to the audience, just a quick introduction, and then we're gonna get into it in the next like 3 minutes.
Awesome. Good afternoon, good evening, everyone. I'm Lumgenia Askew, the founding attorney at Askew and Associates PA. We do estate planning and probate matters and real estate matters as well. And we handle everything from wills, trust, power of attorney. We do probate administration, probate litigation, as well as trust litigation. So thank you so much for having me today.
All right, perfect, perfect. So we're gonna give it 2 more minutes. Thank you so much for joining us. Vivian, how are you doing on this wonderful Monday? So we're gonna start
Hey.
and next, how you doing? How you doing? So we're gonna start in the next 2 minutes. We're gonna allow everyone to just start dropping in. And I would say at like 7:04, 7:05, we're gonna get everything started. So just bear with us for just a few minutes, okay? And we're also gonna do a Q&A at the end of the presentation. So any questions you guys have, just start writing them down, and we're gonna get to all the questions by the end of tonight. Okay, so we're gonna go ahead and get started. So again, thank you guys for joining our part two session to Deed to Legacy. Um, Jeffrey Corleone and I put this together because we saw the value and the opportunity to really impact our community because it's so imperative that we get this addressed. A lot of family members of myself, Jeffrey, and honestly, I think everyone can attest to this, that a lot of people have been impacted by this very topic. But before we go into the discussion, I just want to give the floor to my colleagues, Attorney Askew and Jeffrey, just so they can introduce themselves, and then we're going to go into our presentation. The
Good
floor is
afternoon.
the floor is yours.
Good afternoon. I'm Longina Askew, the founding attorney of Askew and Associates PA. We have two office locations, but they are both in Broward, Lauderdale Lakes, and Coral Springs. We service the entire state of Florida with estate planning and probate matters, as well as real estate matters. We cover things such as last will and testament, revocable trust, irrevocable trust, power of attorney. We also cover probate administration, probate litigation, and trust litigation. We're very excited to be here this evening, and we look forward to having a very meaningful conversation. Thank you for having us.
Okay, the floor is yours, Jeffrey.
Jeffrey Christopher Coral. I'm excited to be here tonight. Just here really to help Reggie out. Anything you guys may need, I am here as his second hand, and I'm excited for you guys to be here. And hopefully, you guys take some information that you can not only just utilize for yourself, but obviously each one teach one. We take the information and we share it onto others, our colleagues, our friends, our families, because someone that we know may be dealing with this situation right now and they have no idea what to do, but you have the information. So let's not take today's information and just keep it till we need it, but let's take it and let's share it. Thank you guys for being here.
All right, so thank you so much, Jeffrey. So yes, my name is Pedro Amande. I'm a licensed real estate professional here serving the community of Broward and Miami-Dade. I've been in the business for 7 years, and yes, when I spoke to Jeff about this particular topic, It really touched a heartstring on myself because I've been impacted myself. So I want to take the time to really present this to everyone that's on this Zoom today, and I just want you guys to leave with some value. I want this to be something that you guys really think about seriously, because it's important. We have to think about the next generation coming after us because we're not always going to be here, you know. So taking the time out to make sure your assets are in order is very vital living in this country. So we're going to start with the presentation. So most homeowners own their property but not their legacy. What does that mean? Meaning you can own a property here in South Florida, of course, and a lot of us we don't know what could potentially happen in the future. But I know that myself, I was affected by this in my family. That something occurred, and we didn't have a backup plan. We didn't have a plan of action because for a lot of us, we don't think about tomorrow, and that's very, very, very important to start thinking forward. So if something happened to you tomorrow, would your property transfer the way you think it will? So I want to just give a personal story. My grandfather came from country Haiti, very small island, very humble beginnings. He came here with $1 to his name, no safety net, no shortcuts, just work ethic and faith. And as good book says, a good man leaves an inheritance to his children's children, right? But according to the state of Florida, my grandfather didn't do that. Although he purchased a property in Miami, and that said property is now $400,000 as we speak. Actually, as prices continue to rise, it's probably a little bit higher than that. I have to double check. But my grandfather worked extremely hard to purchase that property. We had nothing when he came here, and he was able to muster up enough willpower to put a property. And his plan was to have a property so it's all his 7 kids and his wife can come over and have a place to stay when they came from Haiti. But he had no will, he had no trust, he had no updated deed. He was the only one on the property. And he would thought in his mind, I've done everything I can to ensure my family's had a good foundation. But according to the US government, he did not do that. Here's the truth. My family paid the price for learning the rules of this country too late. And I don't want that for anyone that's in this Zoom call today. Tonight isn't about fear, it's about empowerment. So in the next section we're going to break down what actually happens when a homeowner passes away without a plan, how different deed structures can affect control and inheritance, and simple steps you guys can take today to protect yourself and your family. Because legacy isn't what happens to you. Legacy is what you plan for, what you put into a structure. And that's why we have our wonderful attorney today that's going to go deep into our topic. We're going to discuss ladybird deed, which in professional terms is life estate deed, versus a trust. Two very powerful topics we're going to discuss today, and we're going to see how they both relate and if it makes sense. Because a lot of individuals, a trust makes more sense for them. A life estate would make more sense. And we're going to have our attorney today to discuss if that's something that would make sense for your particular situation. And the floor is yours, Attorney Askew.
Thank you so much. I appreciate, you laying the foundation for the conversation. I'm going to go ahead and share a PowerPoint on my end. 1 second, please. Awesome. So I just want to confirm everyone can see my screen, correct?
I can see it.
Okay, awesome. Thank
Yes.
you.
Yes.
Awesome.
Yes.
So we're going to start off by discussing the revocable trust. As Reginald already laid down the foundation. We have when we're talking about estate planning, especially for real estate owners, two of the primary used tools are the revocable trust and the ladybird deed, which is the full term is the enhanced life estate deed. First, we're going to talk about the revocable trust. And before we even get into kind of like the details, one of the best, I guess you could say, contenders for revocable trust is people that own more than one property. And even if you only own one property, if you have minor children, this is probably something that you should pay attention to. With that being said, let's move right along. If I could figure it out. 1 second, please. I'm not sure why it's not going to the next slide. 1 second. I'm gonna have to figure this out so it could be a smoother transition moving forward. Okay. So the revocable trust is also known as a living trust. It is a legal document that allows you to transfer ownership of your assets, property, money, etc., to a designated trustee to manage for your benefit while you're alive. However, you retain the power to revoke the trust, modify its terms, or even take back assets at any time during your lifetime. So I know there's a lot of legal terms being used in this description. So one of the easiest illustrations for a trust is thinking of it as a book bag, or for my ladies, a purse. So the revocable trust is something that holds your assets on your behalf. So if you have a book bag, you can add a pen to that book bag. You can add, if you have a purse, you can add lipstick. You can add, I don't know, other items, right? And whoever is holding the bag or holding the purse would be who we consider the trustee, because they can control those assets and distribute those assets. They're, in a sense, a manager for those assets. And then, of course, you designate your beneficiaries, who are the people you designate to receive those assets on your behalf. So why would you want to choose a revocable trust? In this country, if you have a last will and testament, you still have to go through probate. That is one of the most common misconceptions, even in Florida statute specifically. If you have a last will and testament, you still have to go through probate, which is a court process to transfer your assets from your individual name to your beneficiaries. And so, for example, if a spouse passes away, but their asset was only in their name and it wasn't in their respective spouse's name, we still have to go to court and get a court order to change the title, even if by law or by their will, they already have designated who's going to inherit them. And so that's why people prefer to do the revocable trust, savvy planners and wealthy individuals, because they understand that they want to avoid time, cost, and fees in regards to going through the probate process. And of course, stress and potential family disputes. The other thing is you're maintaining privacy by choosing the revocable trust, because the revocable trust avoids the probate process versus the will. We have to go to court and you're exposing your estate to the public records. And Florida tend to try to protect the estate matters, but you're still able to search the estate. You're still able to see that a will was recorded in the public records. You're still able to see what is going on in the case, even if some of it is protected, versus with the trust, it's completely outside the court process. And so no one is in your business. And then you're also able to stay in control with the revocable trust. With the will, it mostly takes place and comes into effect upon your passing. With the trust, you're preparing for your future, but you're also preparing in a way where it's still everything is in your control. You're able to revoke the trust, which means you're able to change, add, modify, remove, whether it be assets or beneficiaries. And so it offers flexibility. It also helps you plan for a case of just being sick, because sometimes we think about death in regards to planning, but there's other circumstances that planning protects you from. And a lot of those circumstances are medical issues. So if you're in a coma, or you unfortunately are unable to speak, and things of that nature. So illness or age, the trust will also be able to put a person in place to manage your assets by making that trustee take over their responsibilities. Although you can be your original trustee under a revocable trust, typically you designate what we call a successor trustee, which is a manager that will take over in the case you're not able to handle the trust yourself. The other thing is the trust typically prevent family disputes, and I will say this is with a caveat because unfortunately we do see situations where if the person didn't choose the right responsible individual to handle the trust upon their passing, sometimes there are issues where trustees unfortunately take advantage of the situation. So that's why our firm, we do end up doing some trust litigation matters. But for the most part, trustees are responsible. They do what they're supposed to do. And so it avoids disputes versus when there's a will, we do probate administration as well as probate litigation. People tend to say, well, I know they changed their minds, and so this is an old will and it was never updated, et cetera, et cetera. There's less of those issues when it comes to the trust. For the most part, if there's going to be litigation over the trust, it's because the trustee is not doing what they're supposed to do versus the will. People tend to just try to dispute it if they just don't agree with the way the settler, which is the planner, left the provisions in the will. And depending on what the statute says in regards to Florida law, they may be able to be successful in disputing the will more easily than disputing the trust. And we kind of briefly talked about this, about, circumstances that you should consider the trust in. My top two circumstances that I always share with people are minor children and multiple assets. Because if you only have one real estate property, we can always discuss the ladybird deed, and which is what we're going to do next. But if you have more than one real estate property, or you have other assets you would like to add to the trust, some people have assets such as vehicles and they add them to trust. Life insurance, stocks, bonds, those are all assets that can be added to your trust. I also have an example here. So our example says Sarah, a 65-year-old widow, owns a home, a savings account, and an investment portfolio. She has two children and wants to ensure they inherit her assets without the hassle of probate. She also worries about what would happen if she became ill and couldn't manage her finances. By setting up a revocable trust, Sarah can make sure her home and investments go directly to her children without court interference. She can name a trusted person to handle her finances if she becomes unable to do so. She can maintain control of her assets while she's alive and keep her estate matters private. Without a trust, Sarah's children could face months of probate, legal fees, and unnecessary stress. Instead, she is able to create a smooth, hassle-free process for them. And although this states months, probate can take longer than months. Depending on your estate, the amount of beneficiaries, how complicated your assets are, and whether people are disputing them, it could take years. And the other category that I forgot to mention, under the same kind of sub-context of minor children, if someone has grandchildren that they want to provide for, because under Florida statute, you typically are accounting for spouses and children, and grandchildren technically become beneficiaries if their parents have deceased. And so unless you designate your grandchildren to be your beneficiaries, Florida statute would control, and their parents would be the ones to inherit. Then the other issue about choosing to leave assets to minor children, if you're not using the trust, is you can potentially tie up those assets in guardianship, which is a whole nother separate court process because people can only legally inherit and take title once they're 18. So again, if someone has multiple, assets, more than one property, minor children or grandchildren, the revocable trust is technically the better tool for them to plan properly. So with that being said, I know we're going to do Q&A at the end, so I'm going to just move right along to the ladybird deed, which is the alternative estate planning tool, especially if someone's trying to be budget friendly and it just fits their family dynamic. And so maybe they don't have any minor children and they don't have any grandchildren and they only have one home. So this would probably be a more budget friendly way for them to do estate planning. So the Ladybird deed is called the Enhanced Life Estate Deed. We do have this document here in Florida, and this is typically used to transfer real property automatically upon death without going through probate. And how this works is the property owner keeps full control of the property during their lifetime. They can still sell, mortgage, or change beneficiaries at any time. But upon their death, the property transfers directly to the named beneficiaries. The great thing about being able to keep ownership during your lifetime is the fact that sometimes, for example, if someone does like a quick claim deed where they just add someone else's title with them, the concern there is if they choose to sell later on, now they have to get that joint tenant to sign with them. And that person you added may not agree. I also do real estate litigation at my firm, and we do these things called partition actions. And a lot of times it's between children and their parents because the parent was trying to estate plan, they added their adult child to title, and then decided for whatever reason they wanted to sell instead. And now that adult child is refusing to sign because they know that means they're no longer going to inherit that property. And so in those types of circumstances, it would have been preferred for the parent to do the enhanced life estate deed, which means they're not automatically adding that person on title right now. They're basically adding them on title for a later time. And so again, a key feature of the Ladybird deed is the owner can sell, mortgage, or change beneficiaries at any time. And really, that beneficiary only benefits at the time of death. Okay, and another great tool of using the Ladybird deed is it avoids probate delays and costs and ensures a smooth transfer of property and allows the person to maintain control during their lifetime. And it's a more simplified estate planning tool for homeowners, especially when, or if their home is their only asset. And one thing to be mindful of, because I know sometimes people don't necessarily use attorneys for Ladybird deeds. They try to find a template online, or they go down to the clerk's office and get a template from the clerk's office. You have to be very mindful that there is a difference between a traditional life estate deed and a Ladybird deed. And I've seen several mistakes made where people are coming to me after the fact for me to fix their Ladybird deed because what they thought they did and they thought it was a Ladybird deed ended up being a traditional life estate deed. And one of the, I guess you could say, telltale signs that you're doing the wrong deed, if you are going to try to DIY, is if you're being asked to pay doc stamps, basically transfer fees to the county. The other thing is if property taxes increase the following year, that means you did it wrong. So the traditional life estate, the owner gives up control right away. And if they choose to sell at a later time, the beneficiaries must consent to sell, or the owner must refinance to basically pay that person to agree to sell their share. Versus the Ladybird deed is flexible, it's owner friendly, the owner keeps full control, and no beneficiary consent is required if that person chooses to sell at a later time. And this is also beneficial for Medicaid and tax considerations. For full disclosure, I'm not a tax attorney, but we do have a tax attorney in the office. And so this is just general information. I'm speaking on it purely from the estate planning aspect. But the Ladybird deed is traditionally used in Medicaid planning. The property will allow the owner to keep homestead protections so long as they are residing in the property. And the beneficiaries typically receive a step up in tax basis, which may reduce capital gains taxes. You always want to consult an attorney because every situation is very specific and it's based on your individual circumstances. So again, who should consider a Ladybird deed? Homeowners that want to avoid probate, seniors that are planning for Medicaid eligibility, individuals who want a simple alternative to a trust, and property owners with a clear beneficiary plan. And so the other thing to consider is if someone has a rather large family, the Ladybird deed may not be the right concept for them. And here's why. So if you create a ladybird deed, and let's say you have 5 children, and you put all 5 children as your beneficiaries on that deed, God forbid if one of those children pass, if you did not title that properly as making those beneficiaries joint tenants with rights of survivorship, that means probate would still have to be started. And the whole point is the plan to avoid probate. And that's why you need to always consult with an attorney so that you understand the potential consequences of the legal document. Because I've seen this also happen where someone created a ladybird deed, did not use an attorney, had several children, and one of the children passed away. And so they go now to, the remainder children are thinking they own the property outright, but that's not true. The heir that passed away now has to go through probate for their share, and their children get to inherit that portion of it. And so you always want to consult with an attorney when doing these estate planning documents. Okay, important limitations. I know this is a real estate panel, so people could be joining from other states. This is not available in every state. So I am a attorney licensed in Florida. I'm giving Florida estate planning advice. This only applies to real property, so you cannot use a ladybird deed to estate plan for bank accounts or other assets.
I am cook up légumes now.
Oh, sorry. Could you please mute yourself, please? Thank you. So you're not able to use a ladybird deed to, account for other assets like bank accounts or other assets. And again, it has to be drafted correctly. You want to make sure this is a legally sound document, and it needs to be recorded to be effective. I've also seen situations where someone, executed a ladybird deed, did not record it, and then the family members tried to record it after the person had already passed away. If the property appraiser notices that the person has already passed away, they will most likely give pushback and require you to go to probate. And so those are all things to be mindful of. And again, why it's so important to consult with an attorney. I'm just sharing here, if someone's looking to, consult with our office, this is our QR code to schedule an appointment. And then the very next slide is also our contact information. You could give us a call, 954-546-2699. You could visit our website, askew.pa.com. And I did see that someone asked about irrevocable trust. So the reason why, we were focusing mostly on the revocable trust is the average person may not find the irrevocable trust helpful based on their circumstances. And again, everyone is an individualized decision to estate plan. So we always want to speak with the person to see why they're looking to do an irrevocable trust. So unless you're planning for things like Medicaid, and now we're going into more so elderly law, the irrevocable trust is not typically, I guess you could say, the right fit for the average person who's doing an estate plan. Unless you're super wealthy, or you're using it for like life insurance purposes, or you're truly doing it because of Medicaid planning, it's typically not ideal, because guess what? Well, our lives change. People change. More children are born into the family. Grandchildren are born into the family. Assets are acquired. People choose to sell their assets. And the way the irrevocable trust works is once you draft the irrevocable trust, it's not easy to change or modify. You typically need a court order to change it. And so it's not a tool that should be, I guess you could say, utilized as often as some people may think. And so it's always helpful to just call us. We'll talk with you about your specific circumstances and determine if it really is the right tool for you. But on average, most, average homeowners that are estate planning, the revocable trust is the better fit for them.
Awesome. Thank you so much for that detailed explanation. We're gonna go into our Q&A session, guys. So if anyone in the room would like to unmute themselves and ask our wonderful attorney a question, feel free to do so. If not, I do have some questions that were emailed in, and we're gonna go through them. So if anyone would like to unmute and ask a question, Right now is the time. So
Hi,
you can go
this
ahead.
is
Yes, thank you, Val.
this is Val. Everything has an upside and a downside. So I just want to know, what are the cons of a revocable trust?
Okay, awesome question. So one of the things that I would say is potentially a con is going into, for example, creditor protection, because I understand some people, when they think of the revocable trust, they think of creditor protection. And to a certain extent, there is a layer of privacy added, and your assets are not as easily discovered by creditors. However, it doesn't provide the same protection as like an LLC, for example, where there is limited liability, or even a corporation where there is that limited liability aspect. Because the revocable trust, you still control those assets because you're able to sell them, you're able to update the trust and modify the trust. And so, if the right creditor is trying to gain control of your assets, they can find a way to, in a sense, pierce that layer. Ultimately, though, you're still able to retain your homestead protection even through a trust. And homestead is always treated in the state of Florida differently than other assets. So if someone is adding their homestead into a revocable trust, I wouldn't necessarily be concerned for them in regards to creditors having access to that asset. But if they are, maybe they have a very much more complicated um, I guess you could say, portfolio in regards to the assets that they own, then we would need to have a different conversation to think about maybe adding those extra layers, like making sure they have an LLC and other things in place.
Thank you.
You're welcome.
All right. Does anyone else have any questions for Attorney Askew? Okay, Rosie. Rosie has a question for you. Typical cost of revocable trust.
So the services vary based on who's doing the estate plan. Is it a single person? Are they married? Their assets, their family dynamic, how many, beneficiaries are going to be included. At our firm, at least, the services start at $2,500. And it does vary again based on the specific circumstances of the person estate planning.
And Rose, you can unmute as well. Does that answer your question in full, Rosie? Okay, so I did have some questions that came in through email. So this scenario, I own my home outright. I want to pass it smoothly to my children. If something happens to me, if I use a ladybird deed instead of a revocable trust, what could go wrong in a real world situation, and where does a trust become the safer option?
That's a really good question. And so, especially depending on the age of the children, there lies whether the ladybird deed is preferred over the revocable trust. As we discussed a little bit, when children are added to deeds, it causes an issue if, God forbid, the parent passes away while those children are still minors, because ultimately, for them to legally inherit title um, and be able to sell or etc., um, transfer title themselves as well, they have to be 18 or older because you cannot sign legal documents unless you're of age. And so the real circumstances when people are leaving only their minor children on title is now, if something is to be done with that property, the children have to now have a guardian appointed to them through a court process. And it's almost as if you might as well have gone through probate, because ultimately there's still going to be time, money, etc., expenses, attorney's fees for that to be rectified. And so ideally, I tell clients if they have minor children or even grandchildren that they want to make sure that they're providing for, to set up the trust instead. If they have adult children and it's very much a straightforward situation, then in that case, the ladybird deed might be the better tool.
Awesome.
Sorry, I can't hear you.
Okay, can you guys hear me now?
Yes.
All right, perfect, perfect. So we're gonna go to the next question that came in. I've heard a ladybird deed is cheaper and easier, but I'm worried about unintended consequences. Can you explain a scenario where a homeowner chose a ladybird deed to save money up front and later regretted not setting up a trust? Really deep question.
So, yeah, I mean, it's a really good question. And so it's one of the main ones is the situation where it's a minor child added to the title. The other consequence is kind of what we discussed, where they thought they did the ladybird deed, but it really wasn't a ladybird deed. So, two scenarios. One scenario is the person thought they did a ladybird deed, and it ultimately was a life estate deed where they are now basically telling the court, or I guess you could say the property appraiser's office, that I'm going to reside in this property until my death. However, I already have someone else added to title with me that will take over, you know, basically, I'm trying to think of the best way. It's almost as if you gave yourself a lease to your own property. That's what a life estate deed is. It's like, my child owns this with me. I'm legally allowed to remain on the property until I die. And so if you're now transferring that asset while you're still alive, they have to sign off on that and sign the deed with you. And sometimes that causes family friction if the child doesn't want to sell and things of that nature. So now we have to go to court and do a partition action to get a court order to be able to force the child to sell the property. And now the court is going to give them 50% because legally they do own it with you. So that's one consequence. The other consequence is thinking that you're doing a ladybird deed and just doing a joint tenant with rights of survivorship deed. Or I've also seen the situations where someone flat out removes their parent from the deed and from the title, again, not on purpose. They're not using an attorney, they're doing it themselves, they're finding some template online, and they basically sold themselves the property and even had to pay taxes to the property appraiser's office, to the county office, showing that. And so the parent lost homestead protection, property taxes went up, etc. And so there's a lot of issues that can go wrong if you're not at least consulting with an attorney. But the person is right in the sense of the ladybird deed typically is budget friendly. But again, at my firm, we ask very specific questions because we want to make sure it is the right fit for the family and people are weighing their options.
Amazing. And Val has a question. With a revocable trust, do you still need a will?
So you do not technically need a will, but a great estate plan will include what we call a pour over will, even if you get a revocable trust. The reason why it's a great package to go together is because sometimes, as we'll do something one time and then never go back to it again. Most people tend to be that way. And so if you're not constantly keeping up with the changes in your life and updating your trust, that's when the will help you. So with the pour over will, it's basically telling the court that there is a trust that exists. Unfortunately, assets were added after the fact and the trust was never updated. So it's a streamlined probate that would have to be open. The probate would just be open just to tell the court that whatever assets were not previously added to the trust should just be added to the trust moving forward. And then the trustee would take over under the trust after that is completed. And so that is a great tool that most of my clients actually use, is the revocable trust with the pour over will, so that they're basically doing a catch-all document so that if they fail to update their trust, they still have that extra provision and the extra protection.
Yeah, and I think that this next question we have coming up, you've kind of answered it in advance. But the next question is, how should a homeowners think about this decision if they have a blended family? For example, I have a former wife and now I have a new wife, but I still have minor children with the previous wife. As far as beneficiaries who may not see eye to eye in this situation, does labor deed provide enough protection and clarity? I'm guessing that in this question, there's like a family dispute, so they want to know, how to navigate that.
Okay, so I would say that the Ladybird deed is not enough protection in blended families. So I'm actually very happy that this question came up because that is another kind of unique circumstance that would, put you in a category of the revocable trust should be your option that you're considering. And so ultimately, when there is blended families and one, if you do the will, the new spouse can contest that will because Florida statute gives them legally up to 30% of the estate. So now you also have to think about the minor children from the prior marriage. The other thing too is if you come in with assets into the marriage, so from the prior marriage or even premarital assets. So you want to make sure that you're structuring your estate so that your wishes are honored, and it's harder for people to contest your wishes after you pass. And so in the case of blended families, I would suggest the revocable trust. If there is a harmony within the family, there could even be a joint trust so that everyone's on the same page. The new wife with the husband are all on the same page that this is how the children are going to be provided for, including the prior children. But if there is a situation or a point of contention, the spouses probably should do separate trust, and then any joint assets would need to be, handled appropriately in regards to how those would be handled. But at least any assets coming into the marriage would be pre-designated in their separate trust.
Perfect, perfect. And for the two attendees that just joined, we're doing our Q&A session of the panel, the webinar. So if you have any questions, feel free to drop in the chat or you can unmute yourself. But if not, we're going to go into the next few questions that were emailed in advance. So now's the time. If you want to ask the attorney a question, you can go right ahead.
I have another question.
Go ahead.
Okay. Is there protection with a revocable trust regarding the beneficiary and property taxes of a home that's paid for?
That is a really good question. So ultimately, while the original owner of the home is still alive, especially if this is their homestead can still continue to be applied year after year. Upon their passing, though, the property appraiser, even if there is, a trust set up, typically the property appraiser is legally allowed to reassess the property, especially at the time that the new trustee transfers the property over to the new beneficiaries, whether it be their children, their family members, or if the trust instructions were just to sell the home, right out. And so ultimately, under the revocable trust, once the beneficiary legally takes title, because the trustee transfers that property to them, the property taxes can be reassessed and increased at that time.
Thank you. But does the same thing wouldn't happen if you were mentioning that somebody had had the child's name, not minor child, of course, minor child's name on a deed. I can't remember what kind of deed you called it.
The
Maybe it was
Ladybird deed.
yeah, or any other. They put the child's name is also on the home.
I see what you're saying. So yes,
And then person dies, it automatically that house would go to that other person because their name is on the deed.
yes, in regards to the Ladybird deed, so that does normally allow some tax savings because with the property appraiser's office, they wouldn't necessarily reassess the property at the time because title changed while the original owner was still alive, right? It was just a matter of when the person passes away, the child or the beneficiary would give the property appraiser a copy of the death certificate, and title would be updated, but it wouldn't be reassessed as a transfer or a sale. And so we did kind of touch on it a little bit in the slide that there is, a savings in the taxes. However, I have to always be very careful with how I give tax advice because I'm not a tax attorney.
Mhm. Okay, thank you.
You're welcome.
All right. So this one's for the audience. Do you guys have any more questions? Feel free to ask. The next question is very it's a really good question. So if you guys have any more questions, feel free to ask now before we go into the last round of questions for the attorney.
I already asked about what was a downside of the revocable trust. Am I right?
Yes.
Okay. Sorry. I'm good. You answered all my questions.
Amazing. And that's exactly why we put this together, you know. We want to make sure you guys are well educated so you guys can go back to your families and share all the information and prevent any future issues because this particular topic sounds like a headache. All right. So, and this is actually something that is actually impacting the country as a whole, in my personal opinion. So in an event that I am deported from the country and I do own property in America, what is the best way to protect my family? A ladybird deed or a trust? I don't even know what the answer to that question is. I'm glad that they asked that.
So ultimately, there's, in a sense, two ways to think about this because we know with real estate, at least from the seller's perspective, you are able to make title transfers using a remote notary. So, you know, even if you were, for example, in another country and you own property in your individual name, ideally you would still be able to transfer title over while you're alive, right? Using a remote online notary and take care of it that way. With that being said, it's always better to be proactive and to plan. You don't want to wait to be in one of those predicaments to be forced to have to quickly use a remote online notary, etc. Um, but it's one of those things where, again, the same kind of discussion we've been having applies. You have to look at your family dynamic to determine, based on your specific circumstances, is it the ladybird deed that's going to be preferred or the trust that's going to be preferred? But ultimately, at least with the trust, your successor trustee could technically take over because you're no longer in the country, right? You could put that person in place so that they're responsible to sign on your behalf because you're, in a sense, incapacitated because you're not legally, available to make those decisions anymore. But worst case scenario, because I've been doing a lot of panels on this exact topic, worst case scenario, we would be able to coordinate with you, getting a remote online notary involved and having you to basically sign those documents virtually online with a notary.
Awesome. Thank you so much for answering that. That's my first time even coming across that.
It's coming up a
So,
lot. I'm Haitian, so I'm in the community. It's a lot of people are actually concerned about this specific issue.
all right. So as we come to an end, we're 10 minutes away from our closing time for the webinar. I'm going to go over two last questions, but before I do that, I would like to give our audience a chance to ask any questions that may have came up while the attorney was speaking, go over her webinar presentation. Does anyone else have any questions? Speak now, forever hold your peace. Okay, so the next question that came in your experience, what is the most common things families say after loved ones pass away that signals that they didn't fully understand or put together a proper structure in place?
So I've heard I didn't think it was gonna take this long. I didn't think it would be this complicated. I didn't think I would have these problems. So it there's a lot of just, just didn't know. People are just not aware of what it looks like. And so unless they've had someone close to them go through the process, and a lot of times they're just not only are they grieving, they're left in shock. I'll give you an example. One of our clients, the husband passed away before adding the spouse to the deed. And so, the wife was paying the mortgage as normal until I don't know if the mortgage company switched or something happened where she no longer had access to pay. And so when she contacted the mortgage company, they basically told her, well, you're not the title holder and you need to show us that you've now inherited this property for us to continue communicating with you. That happens with the mortgage companies, that happens with the homeowners association. And the homeowners associations, they're almost worse to me, at least, than the mortgage companies because they'll be quick to try to foreclose, on a $400,000 property just over like a $8,000 lien. And so, these are things to consider. People are just it's great that we're having these panels and then people are getting the information and bringing it back to their family and their loved ones because people just don't know what they don't know. So a lot of times they're surprised at how long the process takes. They're also surprised by the attorney's fees. And I'll tell you right now, probate is 5 times, if not more, expensive than estate planning. And so it just be proactive, estate plan, and save your family the stress and the headache later.
Amazing, amazing. So we're gonna go into our last question for tonight. So this one, this one's another one that's kind of dicey. So if one of my beneficiaries has a credit issues, lawsuits, or owes child support, can a ladybird deed expose my property to their problems after I pass? Will a trust shield the asset differently?
So that's a good question. Ultimately, remember with the ladybird deed and even the trust, the owner still owns the property. It's just the title is changed in a way that their beneficiary can more easily inherit it and not have to go through the probate court process. So ultimately, with the ladybird deed, right, until that asset is now officially in that beneficiary's name, it's not going to be exposed to the beneficiary's creditors just yet. So that's one part of the question. And then if it is a joint asset, it's even more difficult. For example, if you have 2 children and only one child has a creditor, that creditor would have to convince the court to basically partition the property just for their debt to be paid when there's another beneficiary on that asset. So jointly owned assets, in a sense, kind of help shield people from creditors too, because on average, it's more difficult for a creditor to convince a judge to, force a sale on an asset just for one of the beneficiaries when there's more than one beneficiary on that asset. So it's a very, I guess you could say, complex question, and each situation would look different. But whether it be under the ladybird deed or the trust, it would be a little bit difficult. This is a joint asset, and the one thing I will say is the trust adds another layer because the trust is owned by a trustee. It's not even owned by the beneficiaries outright until the trustee transfers the assets to the beneficiaries. And so if a creditor is doing a search in the public records, it's going to be more difficult to find an asset that's owned in a trust versus owned in someone's individual name. Oh, and caveat, it also depends on the type of creditor. That's another thing. So it's a very unique question, and different creditors have different rights under Florida statute. So that's also something else to consider.
Awesome, awesome. And we have a question just came in the chat. Do you do asset protection too, beside estate planning?
So we do work with an asset protection attorney. They do asset protection as well as elder law. I know someone asked that earlier. So we are able to work with that attorney to do a more comprehensive estate plan for you that includes asset protection. But if you're coming straight to Askew and Associates, we're primarily doing estate planning, wills and trust, power of attorney, as well as probate matters and trust matters.
How does a pour over work with a trust? Val, can you go ahead and unmute yourself? I was having an
Yeah, it says,
issue.
how does a pour over will work with a trust?
So the pour over will is kind of what we discussed a little bit earlier, where it's basically like a catch-all document that people use to accompany the trust, because ultimately sometimes people don't update their trust and something happens to them. And so the will orders the judge to transfer any remaining assets into the trust. And so it's a really great way to estate plan using both of those tools. And it helps streamline, a very small probate process and bringing everything back to the trust. And then from there, the trustee would administer the trust.
Could there ever be a situation where there's a conflict of something that was written in the will against what's in the trust?
So if there's a conflict, it has to be treated based on when each document was created. So typically you look at the creator that was created the latest. So for example, one was in January, one was in February, would look in February. And then we also want to look at, did those trust assets already, transfer title, et cetera? Because if something has already been transferred over to a specific beneficiary, we cannot say that the will now controls. So there's a few situations where there potentially be conflict, but like I'll give you an example. If you have like a life insurance policy and you have a beneficiary designated on a life insurance policy, even if you now write a trust or a will and say a new beneficiary on those documents, if you don't go back and update it with the insurance policy, that beneficiary that you pre-designated will control. And so that's
Correct.
how those documents work with one another. There are
Okay.
certain situations where you look at the later documents to see what controls, and then depending on the specific asset and the timing, it may be a situation where something that was already done has to be the controlling factor.
Okay, thank you so much.
You're welcome.
All right, and that ends our segment. I hope that everyone found the segment impactful and it got a lot of value. A lot of great questions were asked, so thank you guys so much. All those who emailed their questions and all those that asked questions from our wonderful audience. I want to thank you so much, Attorney Askew, for pouring into the community and taking your time to really provide value. And hopefully, you guys take this home with you guys. Yes, really great questions. Yes. And if you can actually put in your contact information in the chat so everyone knows exactly who you are, Attorney Askew, and of course, you can always book a consultation with her in her office. And any more questions that may come up in mine, you can always ask the attorney and set up a consultation, and then she can help navigate you to your next phase of your process. Um, Also, I'm going to add my information as well. So if you have any real estate related needs, I can also contact me as well. And I'm going to ask my colleague Jeff Cordone to drop his information as well. We're here to help you guys as much as possible. Our numbers are always our lines are always available to you guys. So any questions you have or you want to set up a consultation with any one of us, we're more than happy to assist you, whether that's real estate needs or to help with your will and trust, probate, like we said, life estate versus Ladybird. Yeah, we're here for you guys.
Thank you so much for having me. And I just wanted to say that please consider me as a resource. I have a really large network. I have a network where I even have access to attorneys in other states. And so it doesn't really matter if you're thinking, well, I don't have an estate or probate matter here in Florida, but I do have this other legal matter. Please reach out. We'll refer you to another colleague. And, we're just here to be a resource. So thank you.
Awesome, awesome. And Jeff, do you want to leave anything for our audience before we close for the day, for the night? All right, perfect, perfect.
Well,
Well, again, thank you guys so much for attending this wonderful webinar. If you found this webinar to be in fact impactful and valuable, please drop a one in the chat. And if you would like to see more versions of this, please let us know. We can email us at any time, text us. And yeah, any questions you guys have and regarding any real estate related a real estate topic, please feel free to reach out to us. We're here for you guys. We're here for the community. And yeah, we just want to see everyone in the position to win. Awesome, awesome. All right, guys. So I'm gonna give everyone back their night. Thank you guys so much for attending this webinar. And yes, please plan accordingly for the next generation. We don't want anyone's family members to be impacted negatively. This is so important that we set the right tools and resources for those that are coming behind us. Because at the end of the day, we're not promised tomorrow. And like the story I added earlier with my grandfather, he had no idea this would happen to his family. He worked very hard. He came to this country with literally nothing, and he buckled down, and to the best of his knowledge, he did the best he could with the knowledge he had. But now that he's gone, and we can learn from his situation, I'm hoping that we all can take that and understand how important it is to, yes, the American dream is to own a property, own multiple properties for some of us. But after we're gone, there are going to be ones that come after us, our small children, our grandkids. So we want to make sure that these assets come trickle down accordingly without any issues. This is a very touchy situation for a lot of us, but I hope that we can take some value out of this webinar and really plan accordingly. And with that, I will say good night to you guys all. Miss out, unfortunately, but we're gonna send a recording. Don't worry, whoever that is, iPhone. I'm not sure what that is, but we're gonna send a recording to you. Okay, tomorrow. Okay, yes, you expect a call, Attorney Haskell's Charmaine. Okay, perfect. Yes.
Awesome. Thank you so much. Thank you for having me. Good night, guys. Good night.
All right, bye.